Good morning and welcome to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I am located at 1563 Main Street in Peckville, Pennsylvania, and I am right here with you each and every week at this time on this station to bring you, the landowner, the information you need regarding natural gas development here in Pennsylvania. And as I say each and every week, and mean as much today as I meant last week and the week before and so on and so on and so on. I, Doug Clark, the Clark Law Firm, has not, do not, and will not, never have, never will represent a gas or pipeline company. And I say that today that statement has even special meaning and more significance to me today as it did last week. Now, it's tough to say because it's always the same and it's always true. But there are reasons, many reasons, why I have that position and why I'll never work for a gas or pipeline company. And, this can be an individual situation, but something happened this week, that I was told. So this wasn't something that was said to me by the person directly, but said to a landowner in Pennsylvania, allegedly. So the landowner reports to me and says, yes, the landman, now again, this isn't me saying this, is somebody reporting this to me, says, here's your lease offer. We have a lease offer for you. And there is no reason for you, landowner, to take this lease offer to an attorney. All an attorney is going to do is charge you money, and this lease offer is completely non-negotiable and won't be changed. So you should not go to an attorney because there is nothing an attorney can do for you. Again, I want to stress, this is reported to me, so maybe this is not true, but maybe it is. And maybe you have been told that, or maybe you will be told that in the future. So let's assume that this is true. Again, I'm going to say it one more time. I may say it again. This wasn't said to me by a landman. This was said to me by a landowner who said, hey, this is what the landman told me. So when I say, I have not, do not, and will not work for a gas or pipeline company, again, there are many different reasons. One reason, and I mean there are many, but one reason is a statement like that could be true. It may not be true, but it could be true. And we don't need people to be signing bad agreements, who are uninformed, who are not educated on these documents and these types of agreements. And I'm not saying not educated. I'm talking about you could be the smartest person in the world, but the first time you're handed a gas lease, you're not going to understand it. You need to understand development, operations. You need to understand terms of art, how this process is going to work. You need to understand the loopholes, the ways in which companies can use these contracts to maximize their advantage. So you need to understand that. And if this is your first time looking at a contract, or I don't care if it's your 50th time, if you're not involved in this process, you're not going to be able to understand those things. So when I say we need to make sure that the landowner and people are educated and informed, we're talking about these particular issues because this is in my opinion, a very specialized area. It's a very unique area of law for even lawyers to practice, but a very unique area of law for, of course, a regular, normal landowner, oil and gas right owner who doesn't deal with these issues every day. There's many days that I learn new things, and I deal with this stuff every day. So the education and information is critical to allow you to make the right decision. So if a landman says to a person, here's your lease, do not take it to an attorney because there is nothing an attorney can do for you. It is not because I am an attorney that I have these issues. I think that that is a disgraceful statement if it is made. If it was made. If you listen to my show, you'll hear me say, in doing reviews and consultations. Let's talk about that for a second. Let's pretend hypothetically, and I'm going to tell you that I have, in my mind, no doubt that the agreement that was given to this landowner that was subsequently provided to me is negotiable because I've negotiated it before. But I'm going to put that to the side, for a second. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. So putting that aside for the second, the fact that I believe confidently this agreement is negotiable, let's talk about what an attorney can do with an agreement if it were truly 100% non-negotiable. Now, first off, I have seen only a couple of those in thousands and thousands that I've seen. In this particular case, I have no doubt in my mind that this isn't a negotiable agreement. But just again, let's just pretend. Pretend it's not negotiable. So, what can an attorney do? A knowledgeable attorney who's there to help and assist you. Well, number one, the attorney could tell you their opinion as to whether or not the agreement is actually non-negotiable or something that can be negotiated right off the bat. And that's an incredibly important piece of information. Then, from there, the attorney can review all of the different terms of the lease that are important, relevant, that you need to know about, and of course, any other terms that you have interest or you want to know about. The attorney could literally go through it every line if that's what you wanted to do and if that was what needed to be done or felt was appropriate. But the attorney can go through and they can walk through the lease and make sure that you understand everything with the lease. To make sure before you sign that you understand everything. To make sure that if there are loopholes in this agreement that we see typically used by companies for such things as taking deductions and potentially substantial deductions from your royalty payments, that you're aware of that. That you're aware of it and you can decide how to weigh that fact that indeed you'll have deductions, let's say. You can weigh that against the compensation you're going to receive, the royalty percentage you're going to receive, the other terms in the agreement, and you can consider all of these factors in an intelligent and informed way to make the right decision. To decide, you know what, I don't want to do this. Or, you know what, I do want to do this. Or, you know what, there's things in here that are so troublesome and worrisome to me that I'm not going to do this now, but I'm going to wait and see what develops. You may also say, a good attorney will talk to you about, hey, look, here's what's going on in your particular area. You're given a 5-year lease offer that the company says is non-negotiable, that the company has an option of a 5-year extension. And there are no, let's say, no permits or very few permits for drilling filed in your area. So we can look at this information and say, look, if there's gas there, we would fully expect and anticipate that there will be future development. So, in your particular case, because there is no immediacy, meaning that, hey, there's a drilling permit and they're starting the drill and your property's next door or very close, so there's not an immediate need to say, if I don't sign, I'm going to get cut out and I won't be involved in production. And I'm telling you, you know when you're going to get cut out, in my experience. You know when you're going to get cut out. So when a landman says to you, we need a 5-year lease with a 5-year option. If you don't sign, you're going to get cut out. Well, if you're not going to drill in 8 years, there's a really good chance that I'm going to have another opportunity. I'm not going to get cut out. Now, again, this is not specific advice. We got to look at everything specifically. But if you're meeting a landman and the first couple times he or she is telling you, you better sign this, you're going to get cut out, please be careful. Pick up the phone. Please be careful, because that is extremely unlikely. Again, this isn't specific advice, but that's really unlikely. That's a classic thing. How do you get somebody to sign or do something that they may not want to do? or may be against their best interest. What do? You either motivate them by a positive consequence, or you motivate them by a negative consequence. So what do you say? Hey, landowner, sign this lease and you're going to be rich. The Clampetts, millionaires, you're going to be rich. So that is positive motivation. You're going to be rich, you're going to be rich, you're going to be rich. Oh, sign this pipeline agreement. You're going to be rich. Yeah, those other guys screwed you over, but we're here to help you. You're going to be rich. Here you go. Sign, pen, sign. Positive motivation. Or negative motivation. If you don't sign this, you're going to get cut out and you're going to get nothing. Your neighbors will be rich and you get nothing. If you don't sign this pipeline agreement, this gas will never go to market. You'll never get royalties and you'll get nothing. Here's the pen, sign. So we have positive motivators of you're going to be rich, we're going to make you millionaires, you're going to be rich, money. You know you've heard it. Or you have the negative motivators of, well, you're going to get cut out. That's it. You're done. We'll never get the gas to market. You're not going to get royalty money. You better sign. If you don't sign, we're going to do it anyway. We're not going to pay any money. We're going to steal your gas. Sign. So those clearly, look, history tells us there's a reason why that this is occurring. They're effective tools. It's that simple. They are effective tools. That's why they're used. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember to join me each and every week at this time on this station for All Things Marcellus. So, to continue, we got landmen potentially, again, I have not heard, this wasn't said to me, but I've heard this before, but, let's assume it's true. We're assuming this is true. Saying, hey, landowner, don't take this agreement this lease agreement to an attorney. It's non-negotiable. They're just going to take your money. They're just going to charge you money, and there's not a darn thing they can do about it. Well, I'm going to talk about in today's show some of the things in this particular lease offer that this person sent to me that said, here's the lease the gentleman gave me, and then said, this gentleman tells me that I should not take this to an attorney because there's nothing they can do for me. This is non-negotiable, and the attorney's just going to take my money. And we're going to talk about some reasons, as plain as day, as why you may want to take an agreement to an attorney, even in this type of situation, assuming it were true. Once again, I personally have negotiated this particular lease form. So, if that statement was made, number one, I don't believe it. If that statement was made, if that statement was made, to me is disgraceful. Because if it was made, you're saying to a person, do not get information that may assist you in making the best decision for you, your property, your family, your kids, your grandkids, and so on. Who does that? Why would you do that? Why would you do that? I don't know. And I said there are many, many different reasons why I love to do what I do and work for property owners, gas right owners. But this is a great, great example. I talk about reviews and consultations, and I know it sounds like it's a beaten horse. It's a record has been played way, way, way too many times. But this is an outstanding example. So say this scenario, landman says these things. Again, I wasn't there. Say they do say these things. Landowner says, well, you know what? I hear this Doug Clark on a radio station. Sounds like a really great guy. So I hear this guy, and I hear about reviews and consultations that he does. And he says they usually take an hour or two, which is true. It includes reviewing the documents, me getting ready for the call. I do them all myself, call or in office, whatever you prefer. And then I answer every question. I tell you what you need to know. And so we're going to talk about today this lease form and things that is this person that I would talk to this person about. Just some, because we don't have enough time here today. But also, what this is going to show is like an hour or two of time, an hour or two of involvement. You would find out, again, number one, first and foremost, that in this particular case, in this particular lease, I have personally negotiated it before. So that is going to be really invaluable information that you wouldn't have known if you just listened to the person that said, this is non-negotiable, you can't negotiate it. God, remember everyone, it is easy to say words. Doesn't mean they're true. Doesn't mean they're true. It's easy to say stuff. Just because you say something doesn't mean it's true. Just because a person says, well, you cannot negotiate this lease, doesn't mean it's true. Just because somebody says this is all we ever paid, doesn't mean it's true. I have guys tell me this is all we've ever paid when I have simultaneously negotiated for more money with the same company whose representatives telling me this is all we've ever paid. And it's hilarious. I know it's an untrue statement. Now, maybe that person doesn't know. Let's give them the benefit of the doubt. I'm a good guy. Let's give them the benefit of the doubt. But I know that that statement is false. I know it's false because I've seen it firsthand. I know it's false. But if I hadn't seen it and I didn't know it was false, and the guy says to me, lady says to me, oh, this is non-negotiable, this is all we do, well, if I'm going to believe them, I'll never know that that's not true. So, just because somebody says something doesn't mean it's true. We don't buy that broken lamp in the kitchen, in the dining room. Two kids were wrestling around. They come out and lamp is broken. The kids say, oh, I don't know. It just fell by itself. Do we take that as true? Well, no, they said it. Doesn't mean it's true. My gosh, I could come up with billions of examples. So that's always a fun one because I tried to use the old broken lamp when I was a little kid myself. So stay tuned. I want to walk through this. And this will give us some, several different valuable points I think come from this. One is, just because someone says something doesn't mean it's true. Number two is the value of reviews and consultations to understand what you need to know to make an informed, intelligent decision. And then and there's more value, I hope, with this, but it's going to be exposing loopholes and bad lease terms that you need to be aware of when you're making decisions. And, in my opinion, to show you how companies operate and how tricky these documents can be, and how, if you're not doing a review and consultation with me or somebody who knows what they're doing, get it. And if you're not doing it, you're making a mistake. You're making a mistake. I can't tell you how many people have said to me, boy, I wish I would have talked to you years ago and I did this. Boy, I wish I would have talked to you years ago and I did that. Well, let's never say that again. Let's find out now. So you can always, I encourage you, call the office, learn about reviews and consultations for any type of an agreement, anything oil and gas related. See if we can help you. If we can, great. If we can't, that's okay. But pick up the phone and let's see. Give us a call, 570-307-0702. 570-307-0702. And keep listening each and every week to All Things Marcellus with me, Doug Clark, at this time on this station. I'll be right back after this break. Welcome back to All Things Marcellus with me, attorney Doug Clark of the Clark Law Firm. Remember, give us a call. See if we can help you out. Reviews, consultations. I represent landowners, only landowners, gas right owners, for items like gas lease negotiations. Again, reviews and consultations on any documents and any issues. Pipeline, water line agreements, royalty deduction, shut-in issues, vertical wells, you're shut in. As I say, 8 years or more. If you have 100 acres or more and you're shut in. Vertical wells, Tioga County, I want to hear from you. We're trying to do what we can, and we're going to fight this, so we want to hear from you. Again, unitization issues, surface use agreements, meter sites, any and all contracts, issues related to oil and gas, buying and selling gas rights, you name it. Give us a call. See if we can help you. 570-307-0702. And remember, regardless of location, I have clients all across Pennsylvania. I have clients across the country right now. I have an active client in Colorado and Texas, California, and Oregon. Oregon now we're adding to the list. So clients all over. So really encourage you, don't be afraid of distance. Give us a call. And if it sounds like it works, then hey, great. If it's not going to work for you, then that's okay too. But give us a call. I really want to help everyone we can, and we want to get this information out to you. And that's the truth. It's just the truth. And it's really nice to know that that's what your goal is. And it's great. It's a really great thing. So I really want to hear from you. And I encourage you to, check out our websites. Today's radio show will be up tomorrow morning, Monday morning. And then there are many, many, many hours of radio shows up there. I've been doing the show since 2010. 2010, I started doing the show. So go check out the websites, listen to some prior shows. We have all kinds of different topics up there. And use the websites as resources. And then check out the testimonials. I'm very, very, very proud of those. Check them out. You can go to pagasleaseattorney.com and pipelineattorney.com. Think about it. If you have a pipeline agreement and you're not going to pipelineattorney.com and you have an internet, you have a computer, you have internet, why not? Just go check it out. Use it as a general resource. And always remember, the show is not specific advice for anybody. It's very, a lot of opinions and general information. When I do the when I do the reviews and consultations, we really dive into individual situations. So my specific advice on the show is always get specific advice. But there's a lot of general information, and I try in each show to provide information that's going to be valuable. Maybe you've already had this, maybe you've already signed a lease, but this can be valuable for you if you get proposed a pipeline agreement or any type of other agreement. You'll know that these are the type of things that occur. So I select these topics this way, but of course, this week I just got really fired up when I was told, and just circling back, if you were out for the first segment, you weren't up yet, something like that, didn't have your coffee. Let me reset and say, I was told by a landowner over this past week, and again, this is told to me, I wasn't there. I was told by the landowner that the landman had told him that here's the lease offer and provided him a lease offer, said that it was non-negotiable, said that there was no reason to take this to an attorney, that essentially attorney could do nothing for them, would just charge them money and couldn't assist them, and there was nothing that could be changed in this agreement. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember, join me each and every week at this time on this station for All Things Marcellus. So, landman allegedly says, don't take it to an attorney, nothing they can do. Non-negotiable. Now, what I'm going to do is I'm going to walk through some of the items of this agreement. And, look, cynically, maybe the landman, maybe the company doesn't want the person to take it to an attorney because they don't want the person to be informed. Well, let me back that up. I don't even know if that's a cynical approach. I think that may be a real reasonable way to look at that. That we don't want you to get information that may assist you and educate you in making a good decision. We want you to just sign. As you may have heard me say, when you're approached, the first thing that you should do is put down the pen and pick up the phone and get information from someone working for you, not the company. What a great concept it is when an adversary tells you, because it's an adversarial negotiation relationship. I don't care what anyone says. That's what it is. I assure you, that is what it is. So they say to you, don't get any assistance in this subject, which you may have limited knowledge or even no knowledge, but certainly limited knowledge. Even if you follow this stuff, you have limited knowledge. I'm sorry to tell you, you do though. That they say to you, don't get any assistance because no one can help you. And just sign here. And this is being said to you by someone who's been trained, who understands to a degree what they're doing, and who's working for the other side. Boy, what a system if that works. And I pray it doesn't for us, for our side. So, landman allegedly says you can't negotiate this lease, number one. Now, I'm going to tell you again, I have seen this lease form. I'm familiar with it, and I have negotiated. So, in my experience, that would not be a true statement. So if I did a review and consultation with this person, one of the first things that I would say when the landowner told me, hey, look, this is non-negotiable, I'd say, well, maybe that's true, but that's not my experience. And in fact, I've already negotiated various terms relative to this agreement on behalf of other clients. So if this is truly non-negotiable, that would be a new experience to me because I've personally negotiated this agreement on multiple occasions. So right there, in and of itself, could be a major moment. And maybe that moment is that you negotiate, and I'll just make up numbers, $250 an acre more, $500 an acre more, who knows? If you had 100 acres and you negotiated $500 more per acre, well, you just made yourself $50,000 by having a phone call and a review and consultation and realizing that, well, despite what I was told, yeah, I could negotiate this, and in our hypothetical here, that you were subsequently able to negotiate it for an additional $500, which resulted in an additional $50,000 in compensation for you. Well, I think you want to know that. So that's something that a review and consultation can show you, and then you can decide how to use that information as go forward. But that's only one point. Granted, that's a big darned point that you can actually negotiate it. That's a huge point. But that's just one point. What else could be discussed? Well, I'm going to tell you, because there's a lot that I could discuss in this lease agreement that I'm holding in my hands. But let's just pretend, we're going to just pick out a couple big ones and focus on those because there's too many things, frankly. But let's pick up a couple big ones. Perhaps you might want to know as a landowner, that when you talk about deductions, which are enormous, which can be enormous, and in some cases equal, in some rare cases have equaled 100% of any potential proceeds for royalties have been completely taken away in deductions. Meaning, if your royalty check was going to be $1,000, the deductions that were taken from that check equaled $1,000 or more, leaving you with no royalty. Now, I want to stress that that is rare. I want to say it again. That is rare. And I think there's a lot of misinformation out there on these points. However, it is something that has occurred. So maybe you might want to know that this supposedly non-negotiable lease form talks about gas royalty, and it says that, and I'm going to paraphrase this because I want to get to the biggest ones. So it gives you your royalty percentage, saying it's going to be the revenue realized, which means code word deductions, but goes on to state that they will take deductions for treatment and processing the gas, separating liquids from the gas, gathering and transporting the gas from the wellhead to production or treatment facilities and or to the point of sale, compression or dehydration, and then this one heck of a kicker that you might want to know about. Now, it may not change your mind, maybe it does, but you might want to know about this, where it says in next subsection, any and all other reasonable costs and expenses of any kind or nature. So I'm going to start again. Any and all other reasonable costs and expenses of any kind or nature, incurred involving handling the gas from the wellhead to the point of sale. Any and all reasonable costs and expenses. Well, what if you don't think they're reasonable and the company does? Well, you're going to be in court. Well, no, you're not going to be in court. You're going to be in arbitration. Because, as I hope to gosh every listener knows, unless this is their first time, arbitration is bad. You do not want to be in arbitration. So, When a company puts in language that says they can deduct any and all other reasonable costs and expenses of any kind or nature involving handling the gas, not transporting, handling the gas from the wellhead to the point of sale. Well, maybe then you as a landowner who is presented with this type of an agreement may want to know about the EQT letter. The EQT letter that was sent out to, I don't know, many, many people. Hundreds and hundreds, maybe thousands. I don't know for sure, but many, many people. Many people sent it to me. The EQT letter to royalty owners dated March 2, 2018 from the EQT owner relations team regarding changes to distribution of royalties. So maybe you as a landowner may want to talk to somebody who knows what they're doing, who's working for you, who can explain how that royalty language may be interpreted in the future. And I'm up against this segment here. I'm going to read to you this EQT letter that they sent again, March 2, 2018. They sent out to all these landowners. And this is something you're going to want to know about. It is something you're going to want to know about if you're signing a new lease. You need to know about these things. And you should know about them before you sign a new lease, and you should know darn well what's in that lease and how it may impact you before you sign it, regardless of whether the landman tells you it's non-negotiable. All right, when I get back, I'm going to read this EQT letter. I mean, it's scary. It's scary. I don't know what else to say. All right. I'll be back after this break. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember, join me each and every week at this time on this station for All Things Marcellus and the information you need. And give us a call, learn about representation, reviews, consultations, any and all oil and gas related issue. Give us a call. See if we can help you. Reviews and consultations usually take an hour or two combined. I do them all personally, either in person or on the phone. We can do group calls. We need to get you this information before you sign. Call us. See about the services. See if we can help you. 570-307-0702. Regardless of your location, 570-307-0702. I'll be right back. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Give us a call. See if we can help you. Remember, easy. Pick up the phone. You put down a pen, pick up the phone, give us a call. And if we can't help you, you don't like what you hear, that's okay. But give us a call. I want to help you if we can. 570-307-0702. 307-0702. So resetting for those of you just joining, my friend Dave probably sleeping in this morning. Here's what we got. We got not a hypothetical. I take that back. We got a situation where landowner tells me, landman gives him a gas lease and says, no sense taking this to an attorney. This is non-negotiable. There's nothing an attorney can do for you. Only take your money. So here's the pen sign. Essentially, that's this conversation in this summary. Now, again, this allegedly occurred. I wasn't there, but this is what's told to me. So if somebody tells this to you, then you'll know that this show is really applicable to you. And I've heard many people have told me things like this in the past, so I assume it happens. But again, I wasn't part of the conversation. So I was talking about if this occurred, number one, in this particular case, this particular lease, it was presented as being non-negotiable, if that's true. My experience is I've personally negotiated this lease. So I would say that that's not a true statement. Also, then, we get into the lease terms. Why would you not want to understand what you're signing before you sign it? I mean, my heavens. These are major industrial commercial contracts. You need to understand before you sign what you're signing. I mean, who would not do that? I mean, everybody should be doing that. So we're listening to a representative, because the landman, works for the company, not you, the landowner. So, landman says, nothing you can do about it, can't negotiate it, nothing the attorney's going to do, take your money, here's my pen. Well, here's some things we would talk about. Now, I touched on it here in the last segment, maybe you would want to know if you like, and this was something we would do if you did a review and consultation. I would first tell you, hey, look, even though this landman apparently told you this was non-negotiable, I've negotiated this agreement several times in the past. So right off the bat, that's an incredibly valuable statement, and that's incredibly valuable information you're receiving. Number two, we walk through the agreement. And in this case, we started talking about the deduction situation. Now, what you want to know, I would think, is if they're going to be deductions, what type of deductions may there be? So then it'll help to inform your decision as to whether it's an appropriate time to enter into a lease, maybe wait, try to negotiate the supposedly non-negotiable lease. All of those things may be a factor. So it's darned well important. How are your royalties going to be calculated? In this particular case, one of the deductions that it sets forth that the company can take is that they can take any and all other reasonable costs and expenses of any kind or nature incurred involving the handling of the gas from the wellhead to the point of sale. I'm going to tell you, I do this all the time. This is what I do. That's an unbelievably broad, vague statement, which really allows for a broad interpretation of deductions. And then if you feel you're getting cheated, you say, okay, well, I'll sue them. No, you won't. You'll go to arbitration. And in this, as many, and again, arbitration is bad, and arbitration is, in a way to look at it, you can say, some people say, it's a license to steal small amounts because no one's going to pay the heavy fees and expenses that go into arbitration. Arbitration, again, as a general rule, is very, very bad in gas leases and pipeline agreements for the Pennsylvania landowner. One more time, arbitration is very, very bad in gas leases and pipeline agreements in Pennsylvania. And if a company says it's good for you, you tell them, well, you're going to be so happy, company, you're going to be so happy, landman, because I don't want this provision. So it's good for me, I don't want it, then it shouldn't be a problem to be removed. However, you watch the kicking and screaming that occurs at that point. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Join me each and every week at this time on this station for All Things Marcellus, the information you need regarding natural gas development from the landowner's perspective. So back to this lease agreement. So we're going to do like a little bit of a, not quite, but kind of like a mock review and consultation, but not quite, I assure you. It would be much more specific. So we see here that this gas lease allows for these very broad deductions of any and all other reasonable costs and expenses of any kind or nature incurred involving the handling of the gas from the wellhead to the point of sale. So the handling of the gas is a very unique term, handling, as opposed to transportation, handling. Again, these words matter. Now, what we might want to talk about is, okay, well, what type of deductions are we talking about? Well, that brings me to this EQT letter I referenced in the last section or segment. So here I'm going to get to it. EQT sends out a letter to hundreds, I assume even thousands of landowners on March 2, 2018. March 2nd, 2018. I'm going to read it. To EQT royalty owners from EQT Owner Relations Team, dated March 2, 2018, regarding changes to distribution of royalties. So check this out. This is scary. Here's the text. Since inception of leases allowing for the deduction of post-production expenses, EQT has been subsidizing a portion of the cost to gather the gas produced from those wells. Producing companies, such as EQT, are charged various costs to gather the gas for transport. As part of these gathering costs, EQT has been paying the depreciation, depletion, and amortization costs, which they call the DD&A cost. So EQT has been paying depreciation, depletion, and amortization costs. And, this is EQT, and they're paying return on investment charges. Return on investment charges, which under state law are permitted to be deducted as a post-production cost, as a post-production expense from royalty checks. So what they're saying here is that they have not been charging you depreciation, depletion, amortization, and return on investment costs. But they are allowed to. They say they're allowed to. Next sentence. Beginning in 2018, EQT and its royalty owners will be sharing these post-production expenses, and EQT will be allocating royalty owners with their proportion of gathering charges as related to depreciation, depletion, and amortization, and return on investment costs. As a result, if your lease provides for deductions, you will likely see an increase in the amount deducted for post-production expenses on your March 18 royalty statement. So, this is probably important information you want to know. I would think so. You may still move forward, but it's important information you may want to know because maybe you don't want to move forward. Maybe you want to try to negotiate more. Maybe you want to hold out to see if a better opportunity comes. But maybe you say, you know what? All right, well, this probably isn't a big deal. So, what's this guy yapping about? Let me read you the third paragraph from this. This is EQT's letter to the landowners. Should total gathering expenses exceed the proceeds received from the sale of gas, it's important to note that EQT, unlike other producers, will not issue a negative royalty check to its leaseholders. Think about that one. Boy, aren't they nice guys. I'm going to read that again. Should the total gathering expenses exceed the proceeds received for the sale of the gas, it's important to note that EQT, unlike other producers, will not issue a negative royalty check to its leaseholders. While this is the practice that may be permitted in the language of certain leases, pause for a second. Boy, wouldn't you want to know that? Wouldn't you like to know that before you sign? Well, this is a practice that may be permitted in the language of certain leases. Meaning, are they saying that we can sell your gas, not pay you a royalty, but actually charge you? Think about that. Well, this is a practice that may be permitted in the language of certain leases. EQT royalty owners will not be responsible for reimbursing EQT for gathering expenses. I'm sorry. It's amazing that, you say it with this pride, While this is a practice that may be permitted in the language of certain leases, EQT royalty owners will not be responsible for reimbursing EQT for gathering expenses that exceed royalty payments. My heavens, aren't you wonderful? Wow. What an amazing company. What an amazing company. They are telling you they're such a great company that the royalty owners will not be responsible for reimbursing EQT for gathering expenses that exceed their royalty payments. So look, nothing to worry about. If we sell your gas and the deductions exceed the price that we get for your gas, you're not going to get a royalty statement. You're getting nothing. But be happy because we're not actually going to charge you money for selling your gas. Really, that is amazing. To me, it is amazing. So, when I'm screaming and preaching about these deductions and about the need to understand and know this information, this is the stuff I'm talking about. You need to understand your royalty calculation method. You need to push back, in my opinion, to try to change it. And there are companies that I am getting right now I'm knocking stuff over. There are companies now that I'm getting very good royalty provisions and addendum that mean no deductions. There are a few. And then there are others that say, we won't touch it. You got to know, and you have to maximize, and then you have to make informed decisions. This seems to me, this is beyond common sense. This is just basic. And it's like when they say, oh, you don't need to take this to an attorney. What are they going to do? Take your money? No. A good attorney is going to assist you, help you, make sure you understand the good and the bad, what you need to know in the agreement, and allow you to make the right decision. And if it's a negotiable agreement and you hire the attorney to negotiate for you, they should be negotiating to maximize the financial benefit and property protection benefits to suit your needs in the best way they can. That's their job, and that's what a good attorney should do. And I have never yet, and I have done a ton of them, done a review and consultation, these things that, again, take an hour or two, and never done one where the landowner hangs up the phone or before they hang up and says, wow, what a waste of time. This never happened. Never happened. So this is just one example. And again, there are many others in this lease, but I'm going to get to it. We have one more segment to go. But this is the stuff you need to know. And if somebody says to you, no need to take this to an attorney, this is non-negotiable, this and this and this, why are they saying that? Why are they saying that? That should be unbelievably suspect. And it's not because I'm an attorney. It's not at all because of that. It is not at all. And again, I'm talking about you can start with these reviews and consultations for an hour or two. You know, they're done on an hourly fee basis. Get information for you. Too many times I have seen people, I mean a lot of people, when no deductions was available and they signed to allow deductions and costing them in many, many cases hundreds and hundreds of thousands of dollars and even into the millions. Now, again, that's not every case, but I've seen it. You need to make sure you're maximizing the money and protections. I'm way past my time limit. Got one more short segment to go. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Join me each and every week at this time for All Things Marcellus. And make sure you give us a call, 570-307-0702, and see if we can help you. I'll be right back. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember, give me a call, learn about representation. Do it now, 570-307-0702. I'm going to jump right into it, get a very big issue I want to try to address in a short amount of time here. So, okay, another term that maybe the company doesn't want you to know about or doesn't want you to understand, especially if you're in Tioga County in that area, is this term, a continuous operations provision. What this says is that, and it's normal, at the end of if you had a 5-year lease, if the company starts operations within the 5 years, there's a general rule, and you see in these contracts, a standard term that says they get to continue those operations as long as they engage in due diligence, meaning, don't move some dirt around, sit around for 6 months, move a little more dirt around, and so on. So that's just, again, a rough example. But this lease goes way further. And in fact, it says that, and this is unbelievably important to understand, at any time after the expiration of the primary term. So that means, again, let's create this situation, Tioga County landowner. Now, again, this can happen elsewhere, but in Tioga, this is an unbelievably powerful provision. So it's saying that at the end of the primary, or any time after the expiration of the primary term. So think about this. You have a lease. Company goes out and they drill a vertical hole, cap it, never connect it to a pipeline, and pay you shut-in payments year after year after year. Don't pay your royalties, just pay your shut-in payments and hold on to your lease. With the idea, hopefully that they're going to produce gas from that well at some point, but we all know that they're drilling these vertical wells to just hold your property, not pay you royalty, and not have to pay you another bonus, and continue to hold the property and produce how they want. That's what's occurring, in my opinion, and that's a very strong opinion. But this writes in an incredibly valuable tool for a company who wants to do something like that. So again, pay attention because this gets a little tricky. At any time after the expiration of the primary term. So again, let's pretend you've been paid shut-in payments for 7 or 8 years. We can pick any number we want. So they drilled a vertical well. They put you in a unit. They're paying you shut-in payments and not producing any gas. And now you're years after the primary term. It says if the lease is not being maintained by any other provision hereof, the lease shall nevertheless be extended 1 year beyond the completion of plugging operations of the last well that's on the lease premises to, okay, let me just stop there. So what they're saying is, so imagine this scenario. You have a well, again, vertical well, holding your property, never produced. Now they pay you shut-in 8, 9, 10 years. They're paying you shut-in payments, not producing. Then they decide that they're going to plug this well, which they never produced from, and we would argue never ever had an intention of producing, but did it just to hold your lease and never pay you a bonus or give you a new agreement. So this says if they plug that well, then they have another year beyond the plugging operations in that well to go ahead and commence operations for drilling on another well, either on your property or in your unit. So this language gives them the ability to, and I don't know how anyone could possibly dispute this, drill a vertical hole, shut you in, pay you shut-in payments for year after year after year, never ever produce out of that hole, that vertical hole, never ever produce, just pay you shut-in payments. Then after 10 years, pick a number, 5 years, 20 years, come in, plug that well that they never produced from, then get another year of time to drill a new well, one that actually maybe is for real. So they can now have held your lease maybe 15, 20 years without paying you a dime of royalty and without ever drilling a well that they were going to produce from, and then come back and drill a well a year after they plugged a garbage vertical well that they knew they were never going to produce from, that they used to avoid paying you a new lease. That's my opinion. And again, man, do I hold that firmly. And that's what this language says. So this provision goes on to state, again, you can drill a vertical well, plug it, pay you shut-in year after year after year. Or I'm sorry, drill a vertical well, do nothing, pay you shut-in year after year after year after year, then plug that vertical well that they've never produced from, and then have a year to start commencement of operations to drill another well. And if such operations result in production of any substance covered hereby, then this lease will be extended as long thereafter as production continues in paying quantities. So picture yourself in Tioga County, shut in well. You're sitting there. You're in year 5, 6, 7, 8. Now the company says, we're not going to produce enough. Well, no kidding. And then they go and they plug that well. Now they have another year to drill another well. Did you understand that? Did you ever contemplate that? Ever when you were signing the lease? No, you didn't. Nobody did. But if you read this and you understood this lease at this time, you would know that that's something that could occur. And maybe that's relevant to you. Maybe it's relevant to you. It would probably be relevant to all the other people that are in that situation had they known about this, or this type of language, I should say, before they signed. So don't you think you want to know about that? So isn't that something an attorney can do to tell you and explain that to you? Oh, and by the way, and I'm really short in time, I preach about this all the time. It drives me out of my mind. Here is a term. I'm going to read 2 terms. One called captions. Captions, like a heading. Captions, titles, and headings appearing at the beginning of any section, paragraph, or other subdivision of this lease are inserted for convenience or reference only, and do not constitute any part of the lease, and shall be disregarded in construing or interpreting the language hereof. What does that mean? It means ignore this language in the headings if you ever sue them or get in a fight. And what language might you want to know about? The language is quote, caption, quote, royalties without deductions. That's what it's called, royalty without deductions. Does it mean that? No, it doesn't mean that, but that's what it's called. So when you go into court or you go into arbitration, because they won't let you go into court, you go into arbitration, you say, look, right here it says royalty without deductions. They go, no. Read the lease. That heading caption means nothing and is irrelevant, and you can't bring it into this proceeding. But boy, does it look good when they present it to you. Unbelievable. All right, I'm up against it. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember, put down the pen, pick up the phone, give us a call, see if we can help you. 570-307-0702. Landman works with the company, not you, the landowner. Stop signing bad agreements. And most importantly, have a great, great week, everyone.